Hello everyone, welcome to our mains Samadhan series. So it is an ongoing series where I'm covering mains questions with answers from GS1, GS2, GS3 and GS4. So today we'll cover one question on GS2, that is Indian polity. Now the question is, discuss the Indian perspective on parliamentary supremacy and judicial supremacy. Now before going to the answer, first of all, you should have a very foundational knowledge on parliament, the provisions of parliament and also the provisions of judiciary. So before going in detail to this answer, you need to have a basic understanding of judiciary and parliament, because this question is an intermingling of both parliamentary provisions and also judicial provisions. Now the question is Indian perspective on parliamentary supremacy and judicial supremacy. So it's kind of a comparison between both concepts. Now before going to the intro, now a lot of students ask me like how to start intro, now how to conclude it. Now it's a very basic thing. Your introduction should not look like a conclusion and the conclusion should not look like an introductory speech. Now introduction should look like an introduction. For example, here what I've written is India bears the supremacy of the constitution where the powers of the parliament are circumscribed within the four walls set by the constitution and yet provides a striking balance between various organs, that is legislature, executive and judiciary. Now here I've clearly put a point कि everything is set by the constitutions. The powers of parliament, that is it is the constitution who has set the powers and has also set the limits, and it also gives a balance between all the organs of our Indian political system, that is legislature, executive and judiciary. So here clearly I am giving that it is the constitution who has set the powers. Okay, so this is the intro. Now after the intro, we'll come to the main body, that is the parliamentary sovereignty versus judicial supremacy. So here we need to put up points where we'll prove that judiciary also has some powers, the parliament also has some powers. Now whose power is more? That is basically the question, whose power is more. So we have to give here a lot of examples, lot of provisions, lot of constitutional provisions and also judicial provisions. Now basically this answer can be written like an essay also, because lot of provisions are there. But here from a mains point of view, I've tried to put all those points which are important for mains. Now first of all, parliamentary, first of all I mentioned here what is parliamentary sovereignty. Now parliamentary sovereignty is a concept that believes in absolute supremacy of the parliament or the legislative body. So here sovereignty means here parliament is full powerful. That is what is the concept. But in India, what's the situation? That is what we have to write, because the question is on Indian perspective. Now in India, the constitution has arrived at a compromise between the British sovereignty of the parliament and the American judicial supremacy. So here I've mentioned here that in India it is a mix, it is a balance of both, because in British it is the parliament who is supreme and in America it is the judiciary who is supreme. Now coming to the India part, we are governed by rule of law, and judicial review of an administrative action is an essential part of rule of law. Thus courts can determine not only the constitutional validity of a law but also the procedural part of the administrative action. So it is the court. So I am giving here the thing of judicial review. So it is the court who can determine the constitutional validity of a law. Now it has been also given by court, that is Subhash Singh case versus State of Bihar in 1997. Now we have a written constitution, and the powers and functions of every organ are defined and delimited by the constitution. It is the constitution where we get the powers. There is no question of any organ, not even the parliament, being supreme or sovereign. It means in India there is no absolute parliamentary sovereignty. Now both parliament and Supreme Court are supreme in their respective spheres. Now when I'm writing respective spheres, it means we need to put points where in the respective position, in the respective powers given by the constitution, both are powerful. Now for the first thing is Parliament's amending power of the constitution. It is Article 378. So 368. So in Article 368, Parliament can amend any part of the constitution. So now the question comes, the basic structure. Now basic structure is not mentioned in Article 368. Article 368 has given power to the constitution to amend any provision. No exception is mentioned as far as Article 368 is concerned. So first of all, here the power is given to the Parliament to amend the constitution. Now comes the judiciary part. Now Supreme Court can declare a law void if it infringes the basic structure of the constitution. That is the Keswananda Bharti case. And in the Keswananda Bharti case, clearly the court said you can amend it, but you cannot touch the basic structure of the constitution. Now basic structure is not defined anywhere. From different cases of the Supreme Court has said you cannot touch the basic structure. You can amend the parliament, you can amend the constitution, but you cannot amend the basic structure. That is, we'll give an example here. The NJAC, National Judicial Appointments Commission, was declared unconstitutional back in 2015. Why? Because it was against the independence of the judiciary. Now, independence of the judiciary is a part of the basic structure of the constitution, because in NJAC, in this commission was for appointment of judges. Now in this NJAC, one law minister was added. Now law minister is a part of the legislature. Now when a law minister is added, and he will be the one who will be the part of that commission, who will appoint the chief justice or the judges, so it in a way affects the independence of the judiciary, which is nothing but a basic structure of the constitution as per the Supreme Court. Now Parliament cannot make laws on state subject, that is Schedule 7, thus dividing the powers between Parliament and state legislature. So it means Parliament does not have absolute power on all the subjects. So there is a center list, there is a state list, there is a concurrent list. Now when it comes to state list, there are exclusive powers. Yes, there are exceptions, but exclusive power has been given to the state. So here Parliament also does not have that power to make any laws on state list. Now, bar on Parliament on conduct of judges, Article 121. They cannot discuss the conduct of judges in the Parliament. So it is also a bar on the Parliament. Now coming to the 9th schedule. Now 9th schedule of the Constitution includes a list of central and state laws that cannot be challenged in court. So it means here is an example of parliamentary sovereignty, because anything which is put in 9th schedule cannot be challenged in court. So it was the original provision. But again, you have to give another part, that is again the part of judicial provision. However, in the I.R. Coelho case, that is in 2007, the court declared that constitutional validity of any law, whether it is in 9th schedule also, it can be challenged in court. Now again the power of the Parliament again getting limited power of the Parliament through the interpretation of Supreme Court in I.R. Coelho case. Now Parliament's role in removal of judges, it gives an upper hand to the Parliament relative to judiciary, because if you want to remove any kind of judges, it has to pass through the Parliament. So here even Parliament has the authority to regulate the procedure for investigating and proving the misbehavior or incapacity of the judge. Here also the power is given to Parliament. So when it comes to removal of judges, here an upper hand is given to Parliament. Now coming to the Parliament's power on Article 21. Now see, initially Article 21 was Parliament had a bigger power. If you see Article 21, no person shall be deprived of his life or personal liberty except according to procedure established by law, that is Parliament. It means Parliament can infringe. If it is a law made by the Parliament, then person can be deprived of his life or personal liberty. It was the power given in the original Constitution. Now, how the Supreme Court again made an interpretation. Now, but according to the Supreme Court judges, in the Menka Gandhi case, that is in 1978, due process of law was added to procedure established by law. Now, due process of law is nothing but principle of natural justice. Now, here the Supreme Court has a bigger power when it comes to Article 21. So, it was also added under Article 21, thus limiting the power of the Parliament and increasing the power of judiciary. Now, after this Menka Gandhi case, lot of things are added into Article 20. For example, right to environment in Gupta case of 1987. Now right to passive euthanasia, right to privacy. So a lot of things have been added because of this, because of due process of law. Now the difference between due process of law and procedure established law I have already explained in another video. I'll put the link in the description. You can go through that video, which is a very small video, 5 to 6 minutes, where you can clear cut have a difference between due process of law and procedure established by law. Now coming to conclusion. Now in conclusion, as I said, now how to write a conclusion? Now conclusion should not look like an introduction. Conclusion is always, mostly in most of the cases, I will not say in every question, like mostly it is GS2 questions or any kind of analytical question. Conclusion should have a perspective. It should have a perspective, like what's your perspective? Now in India, there is no parliamentary sovereignty. Rather, it is constitutional sovereignty. It is the constitution which is powerful. However, Supreme Court, being the guardian of the constitution, upholds the rule of law, and it is the constitution which has provided Article 142 to the Supreme Court. Now what is 142? Now we call 142 as the Brahmastra of Supreme Court. Now 142 says, where it gives unique power to the Supreme Court to do complete justice when at times law or statute may not provide a remedy. So this is how we give a perspective. India does not have parliamentary sovereignty, but if you compare parliament and judicial, moreover it is the judiciary which is the guardian of the constitution, and the constitution which is the source of power. So I am giving a perspective. Yes, parliament has some provisions, has some power, but again it is the Supreme Court, it is the judiciary which will uphold the rule of law. And I am giving an example, that is I am giving a not an example, it's a provision, that is Article 142. Like I'm giving a reason, this is the power which Supreme Court can use when they to give complete justice when the law fails to give a remedy. So that's it for today. We'll come up with another question on the next class of GS3, that is economy. Thank you.